Good afternoon, everyone. Today is, if I can find the date, today is March 18th. Welcome to the House Ways and Means Committee Education Subcommittee meeting. We have a few bills on the agenda for us today, some that we've discussed before and others that we have not. The idea is we're in full mode of voting mode for these bills today. So the first bill we're going to take up is House Bill 657. This is Delegate Guyton's bill on behavioral health questionnaires. Alistair, I can't see you. There you go. Alistair, do you have the amendment that we discussed from yesterday on this bill?
Yes, I shared it with Sam not too long before this meeting, so I'm not sure if it's been shared with all of you guys.
Did everybody get the amendment for this bill? I see Delegate Blockridge Carr said yes.
Yeah, it's.
You want to explain what the amendment does, Alistair?
Absolutely. So as stated previously, it adopts the sponsors amendments to change this from a screening to a questionnaire, and also removes a member from the consortium guidance board that will develop the questionnaire. Additionally, there's some clarifying language on the questionnaire. The questionnaire will be used by the behavioral health specialist to carry out the behavioral health specialist duties. And additionally, with permission of a student or a student's parents, it will be shared with school mental health staff, including school counselors, psychologists, school nurses, and school social workers, and a coordinated community supports partnership that serves the student, which is the group that the consortium under 7447.1 funds. So that addresses the amendments before. The reason it's with the permission of the student or the student's parents is so as to not violate the HIPAA health privacy law.
Fair enough. Okay. Delegate Ebersol.
You knew it. So I didn't hear that we talked about identifying somebody at the school level. Did you say that? You sound like you went, like the chair said yesterday, up, but did we identify somebody on the local school level?
Yeah, there's a number of people. The school mental health staff, which includes school counselors, psychologists, nurses, and school social workers.
Okay. And then you said with permission. So does that mean when you fill it out, will there be a place for them to say, like, it won't be like the behavioral health person at the county level will say, oh, look at this, I got to go get permission. The permission will be given when they fill it out, right?
Yes, sir.
Okay, great. Thank you.
Alistair, does this cover the point of it being this collected data being reviewed by the behavioral health specialist or the behavioral specialist in the building?
Yes, the behavioral health specialist will be using this to carry out their duties, which are working in collaboration with local health departments, providing behavioral health training to people in schools and in the local health departments, and generally trying to be the conduit between the schools and behavioral health supports in the county.
Got it. Okay, cool. All right, on the amendments, do I hear a motion?
Favorable.
Second.
It's been properly moved and seconded. Any discussion? Seeing none, all those in favor of the amendment say aye.
Aye.
All opposed? Seeing none, on the bill as amended.
Favorable.
Second.
It's been properly moved and seconded. Any discussion on the bill as amended? Seeing none, all those in favor of the bill as amended say aye.
Aye.
All opposed? HB 657 passes as amended. We'll move on to House Bill 689. This is a Carroll County local delegation bill. I believe there's some amendments that were approved by the delegation. Alice, you want to tell us what those amendments do?
Yes, so we discussed this bill a couple of weeks back, and the bill would, as it came into us, it raises the salaries for the county board members and the county board president, and it also limited the student member to one term. And so the amendment just removes the part that limits the student member to one term and instead just raises the salary for the county board members.
Do I hear a motion on the, any questions on the amendment or motion? Do I hear a motion on the amendment?
Move the amendments.
Second.
It's been properly moved and seconded. Any discussion? All those in favor say aye.
Aye.
All opposed. On the bill as amended, do I hear a motion, Delegate Rose?
So moved.
Second.
It's been properly moved and seconded. Any discussion? Seeing none, all those in favor of House Bill 689 say aye.
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 All opposed. House Bill, thank you. House Bill 689 passes. We're gonna move on to House Bill 140. Oh, excuse me, House Bill 603. I was looking at the wrong agenda. I apologize, guys. House Bill 603 is a local bill dealing with Harford County and appointed members to their Board of Education. Alice, you want to tell us what the bill does?
Yes, sir. So this bill alters the membership of the Harford County Board of Education from 9 members to 7. And it does that by removing, right now there are 3 members who are appointed by the governor. Instead, it will be 1 member who's appointed, and they'll be appointed by the county executive, subject to the advice and consent of the county council.
Okay, any discussion on the bill? Seeing none on the bill, do I hear a
Move
motion?
favorable.
It's been properly moved, and do I hear a second? It's been probably moved and seconded by Delegate Rose. All those in favor of the bill, say aye.
Aye.
All opposed. Okay, House Bill 603 passes. We're gonna go back up to House Bill 146. This is a bill that we have not discussed in this subcommittee yet, but this is about the reportable offenses. And I'm gonna ask Alistair to walk us through the bill and then walk us through the potential amendments that we might have in front of you. And this might be a long discussion, so let's just have a discussion about the bill. Alistair, go ahead.
Thank you, sir. So under current law, before this bill would go into effect, if a student is arrested for certain crimes, the arresting officer must notify the school of that arrest. The bill would have altered that in a variety of ways. It would have limited the number of crimes in which a student could be arrested to only violent crimes that occurred off school premises, not an event sponsored by the school. It would have made the report occur at the point of the student's adjudication rather than at the point of the arrest, and would have made reporting permissive rather than mandatory by the state's attorney rather than the arresting officer. Additionally, the bill requires that reporting requirements be done every year about what's going on with reportable offenses and given to the governor and the General Assembly. And it also has some provisions pertaining to students with disabilities, ensuring that those students with disabilities have their attorney present when there are issues related to a reportable offense, and that those students may not be suspended or expelled if the reason for the reportable offense, if the reportable offense was caused by the disability, which is required under federal law, but just reiterated here under state law. So that is the bill as it came in. The amendments, however, return many of the crimes as reportable offenses, which I can get into if you guys would like more detail. It also, okay, well, let me just finish the whole spiel and then I'll get into it. It also changes from the point at which reporting happens from no longer at the point of conviction, but now at the initial appearance or arraignment, and it makes the reporting again mandatory. Additionally, there's an amendment that requires that each county board of education will look through the past 5 years of data that they have on reportable offenses, and subject to federal and state privacy protections, report on race, ethnicity, disability status, and gender of any students who were charged with reportable offenses or arrested for a reportable offense. The crime for which the student was arrested, and any disciplinary actions the school took. If the gender, race, disability status, or ethnicity would reveal who that student was, then you would only require the other 2 categories to be reported so that we're not violating students' federal rights. And that report would be given to MSDE, and then MSDE would compile that data and issue a report to the governor and the General Assembly, so that for the next session, you guys would be aware of what has been happening in schools over the past 5 years.
Okay, any questions? I saw Delia Hartman had a question. Delia, or did you not have the question anymore?
Just some clarification. So you're talking about some of the offenses removed and everything else. So in terms of someone who's not a lawyer, how does this change it as far as just layman's terms? This is struck, this changes reporting, just simple English.
Yeah, absolutely. So I'll tell you what is struck. So language about distributing drugs is struck, except for related to being a drug kingpin. That is still a reportable offense. Manufacture of a destructive device or a false statement regarding toxic material is left in. It's removed. Second degree assault is removed, but first degree assault is left in. Motor vehicle theft is removed. Inducing false testimony to avoid a subpoena is removed. Things that are left in: first degree burglary, aggravated cruelty to animals, bringing a weapon to school, and any crimes of violence, which is a long list, but includes abduction, arson, kidnapping, manslaughter, murder, rape, robbery, carjacking, and many other crimes. I have a list of something like 45 crimes here. So a lot of stuff is still left in there.
Okay, so drug kingpin, but other drug, so distribution would not be reported, but a drug kingpin, so that's probably someone that's not spending much time in school because they have a ulterior business, a business outside of school. Assault, motor vehicle theft, that's not reported, or that is?
Motor vehicle theft is not reported. However, carjacking would be reported. So any crime of violence.
How about rape? I noticed that was a whole paragraph.
Yes, rape would be reported.
Would be reported, and yes. Then the okay, there's enough removed to give me a huge reason for concern. So thank you.
There's enough removed to give you huge reasons for not being concerned or being
concerned as far as what we are removing is not reportable. I mean, how can we think that some of these things that are happening shouldn't be brought to the attention of a school administrator or something, so that the school administrator knows what the potential of their students are? I think I just feel that helps them do a better job as an administrator and can help protect other students. So what's our motivation of suppressing the information?
So I believe that oftentimes under the current law, students are arrested, may not even be charged or anything, and they end up in this limbo state where they're expelled from school as a result of it, and it ends up not being a thing that ever results in anything. And sometimes they can be arrested for, something that it wasn't even them, or they're just like hanging out at the wrong thing at the wrong time because someone assumes they're in a gang or something like that. So I think the intent is to, avoid those circumstances while still ensuring that our schools are safe.
I don't see anything in here that says they have to be suspended for when those issues are reported, but my concern would be just the fact of the administration knowing the potential of their students. So if there's something that makes them suspended right away before they're found guilty, I don't necessarily agree with that, but I do agree with the administration being informed.
There is language. It doesn't require suspension, but it seems to suggest suspension in cases of rape, which is still left in a case of alleged rape against another student. So in that case, specific language in current law, and that would remain in this bill. But yes, you're right. There's nothing else about requiring or not requiring suspension or expulsion.
Okay, thank you.
Thank you, Delegate Eversole.
Thanks. I think there's similar questions to what Delegate Hartman had. The report, a report of this has to be delayed until they are arraigned. Is that what, did I understand that correctly? Okay, so for a period of time, there could be something that happened outside of school that the administration wouldn't know about and wouldn't be prepared to be able to deal with the possibilities. And I'm talking about things less serious, like an assault, like if there was a fight over the weekend outside of school, if students were arrested. And by the way, arrests can mean paper arrests too, and they can be cited. That's also an arrest. I'm concerned that if the administration doesn't know that those people are coming back together for the first time in the building, they won't be prepared to keep an eye on things. I don't think they should suspend students. And also, I'm worried about that delay where they might get the information, indirectly, because a lot of times communities talk. But I'm concerned that that immediate ability to be alert in their buildings might be compromised if, in fact, they don't have a sense that there was an arrest. And of course, you can go deeper than that. If you have a potential sexual offender, kids could be in the same classroom or in the cafeteria together.
Well, I would say that in testimony we heard that it's often the case that on the point of charging, which happens immediately after arrest, it's a condition if there's a likely, in the judge's opinion, it's likely that the student's going to be interacting with their victim, that part of the ability to be released is that you don't go to school with that victim, or you have some sort of restraining order or something like that. So okay. I think that is often covered in practice. Additionally, I think we also heard in the testimony about this bill that it's not always the case that the information is shared under current practice with teachers and others in the school. The only requirement is that the superintendent and the principal know about this. So it may be, but under current practice, there's not a requirement that other people in the school are informed. And
right, and oftentimes, from personal experience, they wouldn't inform us. But we also knew that they were, like I said, we often had an idea because the communities talk a great deal. But I just think to have an administrator be aware of a situation so that they can be alert for the possible continuation. And you're right. Okay, so let's get away from the sex offender one. You kind of covered that, but in a lesser situation where there's been an assault, there's been a fight, if we have to wait, if the administration is not given that information, it'll put them at a decided disadvantage in trying to maintain control. These things do spill back into the school. This is frequently the place where they're first back together after something like that. So I'm concerned about the delay in reporting some of these. That's there I go. I'm done.
Thank you. I did see Delegate Guyton. Delegate Guyton, did you want to ask a question?
Thank you, Mr. Chair. I believe that Delegate Ebersol and really covered most of my questions there. I think I agree with his statement that we just want to make sure that anything that could erupt into violence in school is covered in this bill and not exempted. And I believe, and I've been talking to Lisa Jordan, she's been watching on YouTube. I believe you've dealt with all of the concerns of sexual assault, so I'm okay there as well.
Thank you. Delegate Hartman.
Thank you once again, Mr. Chair. With as I said, the bill is concerning. It's even starting to concern me that Delegate Ebersol and I are thinking along the same lines. But to add on to what he was saying with the delay in reporting, drug kingpin is a pretty high, pretty high in the rank of drug dealers. So you have some pretty heavy drug dealers that could be arrested or whatever, and not alerting the officials. And we could have, that person using school as, another place where the drugs are being sold or distributed. So it is really concerning. And I think aside from some of the really heinous crimes, I mean, it's so important to me for the administration to know what's going on. I just repeating, sometimes you say something twice, it sinks in more. Thanks.
You want to say it again for us, Delegate Hartman? Are you good? Delegate Rose, Delegate Hartman already covered what you.
I think so. The sexual assault, the delay in time is a great concern to me. So I really have a lot of issues, but it's all been said, so I'll be quiet. Thank you.
Thank you, Delegate Ebersol.
Yeah, and to offer a possible positive. I think one of our concerns is that students will be suspended and without really due process. I mean, that's a deeper thing. What I'm talking about is just being alert and aware. And I think perhaps if we got something in here that said the school can't take extreme disciplinary action based on the report, I think that because I believe that's one of the concerns. I think it's why this bill is in front of us, because we're trying to avoid a pipeline situation here where a kid does something or maybe doesn't do something but gets arrested for it, it hasn't been adjudicated on it yet they're suspended from school. And then what do they do? So, this is a whole pipeline situation. So I think if we could tamp down their ability to deny educational services in most cases, I would be comfortable with that. I'm just, like I said, if they're in the building, so I think that would be a balance point. I hope it might be.
Thank you, Delegate Eversole. I think, for this bill, we're out of line with most of the states, where most states, it's only triggered for a reportable offense if it's down a line going towards adjudication. It's usually not at arrest. I would also say that, this bill, what Delegate Eversole kind of hit this point too, is that a student can be removed once a report is given to the school system. They can be suspended or expelled from the school and triggered. There's nothing preventing a superintendent or a principal from suspending that student. And it happens so many different times where students are being suspended and expelled for a simple arrest, which most arrests, about 60% of them, are gone after a few weeks. They no longer exist while their student is at home now or suspended because of that, because of said certain arrest that happened that's reported to the school. I think what we came to the conclusion of is that if it's later on down the line when it's reported to the school, is a good compromise here in this legislation. I don't think any of these should be reported if it's not nonviolent, honestly. But I think this is a middle of the road where we are right now. And also in the bill, it also has pieces on it about reporting requirements too, and looking back at the data to see how many of these suspensions happen, how many of these of these arrests when the school system is notified, how many have led to suspensions and expulsions. And so there's good pieces in this legislation that I think are fitting, and I think we all would have some good ground on. I wonder if there's any other questions or comments on the bill or the amendments. Okay. Delegate Eversole, you had an idea that you propose.
What I said earlier?
Yeah.
Before this? Yes, that while we would allow informal information to be shared with administrations about events that happened, perhaps with particular students, it wouldn't have to be, we would say that they would be permitted to do that in the interest of school safety. But at the same time, that schools could not take disciplinary action based on the arrest alone. They could only do that based on either at the point you said I don't have the right term, but when they're first brought before the court, or even at the point of adjudication then. So that would be my suggestion, because I think I want to stay away from having kids be suspended when we don't know if they're really guilty. At the same time, if there's been an issue, perhaps, I don't know how we would, what language we would use for informal reporting to school administration, superintendent, or principals.
Alice, do you have any idea?
I think you could, if you wanted to amend this bill to say to leave the reportable offenses at the point of arrest and say that no disciplinary action could be taken. I think that there might be some issues with that from schools, but I can't say off the top of my head. I think that is a policy decision that you guys could make.
Okay. Delegate Hartman.
Thank you, Mr. Chair. So are these offenses here are inclusive of what happens in school, correct? So if If the
The-
charges,
These offenses are only things that happen outside of school. And the reason for that is because the school would know if something's happening at the school. So if someone's selling drugs and is caught in school, the school will know about that. This is for something that occurs not at school and not in a school sponsored activity or field trip or something like that.
now, I know this is the chair's bill, but with the amount of consideration and work that may be needed, is this something you're asking for suggestions? Should this be put to a summer study or?
Nope, not asking for any of those types of suggestions.
Okay.
No, you're Hartman. Thank you for that, though. Let's see if we can. Let's go back to Delegate Ebersol's thing. And Alistair, you said we can possibly add that as an amendment.
Mm-hmm. I think that would certainly work as an amendment. It would be a different policy than what is suggested here, but
Got it. I think that would be something that I'm not sure if the
leadership.
Yeah, correct. Yeah. Delegate Guyton.
Yeah, thank you, Mr. Chair. I was just hoping we could reiterate exactly what that amendment, or sort of what that amendment would look like, just so we know.
Yeah, so as I understand Delegate Ebersol's suggestion, it would leave in place these changes to make the reportable offenses focused on violent crime and some very serious nonviolent crimes. But at the point of arrest, schools would be informed about this information. They could, however, not use that information to discipline a student until either the first arraignment or the case was adjudicated in the end.
Thank you. I believe I could support that and the bill with that if the sponsors were okay with it.
But as you said, Alistair, that changes the direction of the bill.
It does, yes. That's right.
Okay.
Tell me, oh, excuse me, Mr. Chair.
No, go ahead. Go ahead.
Tell me now, you say it changes the direction. What do we perceive to be the original direction that we are? Because that's important. I want to listen.
So, I mean,
that we are sort of getting rid of here or whatever, that we're moving.
The original direction is that the schools are not, under the bills that came in, the schools are not informed until the case, they may be informed when the case is finally adjudicated. They're not informed immediately. I mean, I think there are issues with discipline. There are also privacy issues. If a case is going to, as the chair of this committee just said, that a case is likely to result in 60% of cases with charges being dropped and no further action, or 50% of cases, the case just fizzles out. I think that in that case, you're potentially violating the student's privacy and revealing information that may color the way that they're treated at the school unfairly without due process or anything having occurred. So that's a concern. There's also the concern about their being disciplined. So, I mean, it's a difficult issue. You're weighing school safety on the one hand and students' rights of privacy and their right to a due process on the other.
Thank you.
Okay. Do you, Delegate Ebersol, are you cool with the way it is now then, without that amendment?
I have the same concerns I had before about having difficulty managing a school building if there's been things that have occurred that administration just is sort of blind to.
Yeah, well, let's do this. I know it's our first time really discussing this bill. I know the chairwoman, really would like to move this bill and also would like for us to be thoughtful about the bill too. So let's hold the bill for now, and we'll come back to it and try to figure out how we could, come to a consensus on it. But I do want everybody to take some time to review the amendments. I think the amendments are good that we have in here so far. And it does get to the point, and I think we got to just think about privacy versus the student being suspended, for these types of things. And I know Mabe had a lot of angst about this bill, and we resolved at least some of those, not all. So with that said, let's hold this bill for now. We are going to be meeting, told you guys we're going to be meeting every day this week, and Saturday is included on that meeting. So let's move on to House Bill. Where's my agenda? So we're going to hold House Bill 146. Let's move on to House Bill 758. This is a bill that we have not discussed yet, but we've had a public hearing on. Delegate Ivy.
Mr. Chairman,
Yes. Do I hear a motion to move unfavorable on this bill?
so moved.
Second.
It's been properly moved and seconded. Any discussion? Seeing none, all those in favor of the unfavorable say aye.
Aye.
All opposed. Delegate Hartman, Hornberger, and Rose are opposed. House Bill 758 has been moved unfavorably. Thank you all. Thank you all. Thank everybody for being here. I would like for the subcommittee to stay on, as we do not